This is all theater. This is all just political theater.
Political theater. Political theater.
Pure political
theater.
Theater.
Political theater.
The
nefarious,
significant and protracted
political theater for political theater's sake.
I yield back.
From Washington, this is Political Theater, Roll Call's review of the spectacle of politics on Capitol Hill and across the country. I'm Jason Dick.
Well, welcome back to Political Theater. This is a pretty busy time in the nation's capital. We've got a reconciliation debate going on. The president got back from his tour of the Middle East a few days ago, and there's a lot going on Capitol Hill. But there's also a lot going on at the Supreme Court. And so I think this is as good a time as any to talk a little bit about the Supreme Court, what's been going on there, not just the cases that we, have heard oral arguments on, but what's coming up, also some of the dynamics of the court that we've seen develop, particularly over the course of the last year or so. And then there's some other outside news. And what better person to talk about the Supreme Court than our own Todd Ruger, our legal affairs editor here at CQ Roll Call. Todd, welcome back to Political Theater.
Thank you, Jason. Always good to be here.
So again, I think the rapidly evolving settings for the Political Theater podcast. We're in the old podcast studio. It just works better for talking to one another
100%
in person.
100%.
When there's more than one person, we like to go in the old TV studio. When it's just me doing somebody remote, like over in the glass cage of emotion. So, we like to keep people on their toes if they're watching YouTube, just to think like, is this my favorite podcast, Political Theater?
I believe every change elevates how good I'll do on this podcast. So I'm ready.
Well, before we talk about the court, the Supreme Court in particular, I do want to talk about the race that we ran last week, the ACLI, that's the American Council for Life Insurers Capital Challenge. This is this very unique race in the Washington, D.C. area. It's a 3-mile, not a 5K. It's a 3-mile. We don't need the ACLI Capital Challenge is such a great race. It doesn't need that 1/10 of a mile. It's fine with just 3 miles. It's over in Anacostia Park. It's members of the executive branch, legislative branch, judiciary, and members of the press teams. You've run it several years. That was the 10th one that I ran last Wednesday, and you have frequently been able to beat all the Supreme Court justices that run it. Last year, we had Brett Kavanaugh run. That wasn't the first time that he has run it. Ketanji Brown Jackson and Amy Coney Barrett. I think that Jackson was the only Supreme Court justice to run this year. But you can say as a legal affairs editor, though, that you beat them all. You beat the Supreme Court.
That's right. Yes, there's certain things at which I excel over the justices even. This was one of them. It's a really fun event. I know you love to run it. I don't know, did you get an award for doing like your 10th anniversary one or something?
I don't think so. I mean, at least I don't know. I mean, the medals are kind of new. I mean, they used to give them out just at like big intervals, like 35th anniversary, 40th anniversary. And now I feel like they're just giving out the medals. But I mean, the medals I like them. They're fun, but they're also like a participation trophy, right?
Yeah.
So, and as a hard Gen Xer, like I'm like, okay, fine. Like I participate.
Oh, all right.
Like,
See, I don't take them. I'm like, I don't need that stuff to know that I've accomplished something here this morning. But it is fun to race against these people that you cover or that you see in a different context. And I really think it's a fun race because of that. I think it's for charity too. So.
Yes. A lot of money goes to financial literacy for charity for minors and so forth. It's a great event. And also we should state too that CQ Roll Call is a sponsor. We do advertising. We do advertising trades and stuff like that, so that they can get the word out about it. So I don't think that has compromised my integrity as a runner in it or as the editor of CQ and Roll Call. But I think the fastest time I've ever had in those 10 years was just below 30 minutes. It was like 29:58, barely, and that was in 2014. This time around, my time was 33:32. That was good for 458, I believe, out of 528 participants. So,
Nice.
I'm solidly in the lower quartile of all participants. You are much faster than I am. What was your time?
My time this year was somewhere about 7:15 a mile. I've run it in 6:21 a mile. That was my best time. But I've noticed that the whole thing is getting faster.
Yeah.
My 6:21 time from back in the day was something like 12th place. And now I think this year it would have been 50th place or something like that. I mean, there's just a lot of fast people that are starting to run this race. And I think somebody from the Washington Post runs it at a collegiate pace.
So your finish time was 21:43. That was good for 31st place out of 117 print journalists.
Oh,
I know, print.
What about overall though?
You were 90th out
Yeah.
of 528 overall.
Yeah,
So-
it's just, I mean, it's just gotten so fast. And the winner was something like 15 minutes, right?
I believe so. I will check that in a sec. Wait, I lost. This is tech in real time with people who are like me who are not particularly techie. I was 108th out of 117 print journalists. 458 out of 528 overall. And then the top finishers, the overall winner was Jack Butler of National Review, and he did it in 15:45.
Yeah.
So a 5 minute and 15 second pace. There's also another legal wrinkle there too, which is that the Solicitor General of the United States, Dean John Sauer, who's made quite a few arguments in front of the Supreme Court just in the last few days, he was the fastest member of the executive branch, even though the Solicitor General is sometimes referred to as the 10th Justice. He is a member of the executive branch. But Sauer ran it in 24 minutes, 54 seconds. And that's an 8-minute, 18-second pace. That's not bad. That's fast.
That's great for somebody that the next day had to argue in front of the Supreme Court about birthright citizenship and nationwide injunctions. So,
yeah, and to your point, it is getting. I feel like it is getting faster. Like, again, my pace is not gonna. I think the Olympics are probably out of the question for me in 2028, maybe 2032. But still, 11-minute and change miles is not the worst ever, particularly for a 54-year-old man who's a little out of shape and a little overweight, as I am. But I was like, almost dead last. And then on Saturday, I ran a 10K. Lawyers Have Heart, which went around Haynes Point, is really nice, and I had a 12-minute, 27-second pace, and finished in an hour and 17 minutes, and I was almost dead last too. I definitely beat like the 5K walkers, which I was pretty happy about. But I'm like, wow, I mean, this is a fit place. So
it is, and I think the reality or the way to look at it is you're just racing against yourself. Honestly, I mean, like you're trying to self-improve. There's no way you're gonna.
Your race,
you're never going to, you're never going to win these things. There's always going to be somebody younger and faster. So,
all right, let's talk about the Supreme Court. Now that we've lost all of our listeners,
right? Yeah, this is great.
We're like,
the pressure's off.
Yeah,
Nobody's here anymore.
I thought this was about politics. It is. There's nothing more political than slow foot races. Or not everybody was slow. The winners, obviously, that's pretty speedy. But let's talk about the Supreme Court. I mean, you've been covering it for a long time. You've actually written a few books about it. I told you I was going to tell you about that. For some reason, this came. Oh, it was because Christina Bellantoni, who will be my guest next week with another former roll call editor, and she'll be my guest with another former roll caller, Netta Simnani. They're both teaching now, teaching journalists. She put in her column for Roll Call today a reference to an ebook that Rebecca Gale had written about internships called Best Intern Ever. And I remembered that you did ebooks also.
That's right. Yep.
Did you do one or two ebooks about the court?
I did one ebook about all all the documents there's a bunch of internal documents when the White House decides who to nominate to be a Supreme Court justice. And there's a mandatory 12-year period in which they are kept secret after the president leaves office. And so I did it was right around the time that I think it was Obama's, or I can't remember whose it was that just got released. And so I went back and looked at all the presidents that it was available. Yeah. And I was able to look at the inside deliberations about how to pick which justice and whether they would be good on the court or not. My favorite thing I found out there was going to the Reagan Library out in California and looking at the deliberations about Justice Kennedy and his nomination and what they thought. And there was a mention that he would be maybe a little squishy on gay rights, that maybe he would be open to it. He had made a ruling in some Navy case that just briefly mentioned something about rights, and they were like, well, this might be bad. But then it turned out that he was the leading person that wrote all of these opinions that opened the door for gay rights and eventually wrote the opinion to legalize gay marriage. So, I mean, you just see how this like little snowflake can turn into a snowball and roll downhill. And I think it was something like 30 years later, wow, the legalization of gay marriage turns on Kennedy's vote.
Did you say the Reagan Library too? Because this has come up recently, because there's a big Air Force One in the middle of the Simi Valley Reagan Library, and that's come up because of the chatter about the government of Qatar gifting a Palace in the Sky 747 to the United States and to Donald Trump, where he says that he'll put it in his library, which I don't know, don't want to get into that, but yes, I was thinking of the Reagan Library even before talking about Rex. And then you also wrote another book too, that was
University of Pennsylvania.
University of Pennsylvania, yeah.
And they would pick a journalist who covered the court every year to write a book about that term. It's probably around like 40,000 words, but I did it in a month. And I did it while I was still working here. And I did it when it was Kennedy. It was the term that Kennedy retired at the end. Mm-hmm. So that kind of scrambled the whole book. And so, yeah, that was quite a lift for 1 month.
Also, like, I've been here since 2011, and, I've never heard you brag about that book. If I had written a book like that, I would be like talking about it. Like I'd still be going out to lunch on that. So it's to your credit, to your modesty, that you're not talking about your book. So that's why I wanted to embarrass you a little bit by bringing up your books.
Yeah, I never talk about it. That's true.
So that's all by way of saying you're pretty qualified to talk about the Supreme Court and the dynamics which you have been observing for several years, first as a staff writer and now as the editor. And the thing that I think is, when we were sort of prepping for this podcast, that I think is the most interesting shift, this dynamic, that sort of is beginning to define the court, is that for so long we're accustomed to this idea that it was a 5-4 court. Like there were 5 conservatives and 4 liberals, and then when Barrett got on the court, it shifted it to being a 6-3 court, and there are all these sort of dynamics of like, well, now the conservatives have a super majority and they can just run roughshod over things, and obviously that there have been a lot of rulings that happened that never would have happened if Ruth Bader Ginsburg was still on the court in the last couple of years. The Dobbs decision overturning the federal right to abortion being the most prominent. But it seems like what we're seeing as the court kind of develops, and particularly as it interacts with this current administration, is that it's not so much a 6-3 court, it's more like a 3-3-3 court. So let's talk about that a little bit.
Yeah, I mean, these are just ways that I think people think about how this court operates. For a long time,
it also sounds very sports-like too. It's like a zone defense. Let's go into the 3-3 zone defense, guys.
Right. Yeah. It's like it's football. Which defense, which offense should we play? Mm-hmm. But if you're a litigator, you're looking at these types of things to decide where to focus your attention, where to focus your argument. But yeah, for a long time it was 5-4, and the idea was this is a conservative court, and it had been for a long time, and the question was just how far right would it go? every term, right? And then there was sort of a limiter on it. And the limiter used to be Justice Kennedy, who would sometimes, who was thought of as the swing vote, even though he hated that term. And then he would move over sometimes with the liberals on things. And then when he left and Kavanaugh got onto the court, it was more like, okay, feels like that's a little bit to the right. Now it's going to be Roberts' court. Roberts is going to be the one that determines how far right it goes and how fast. We saw a little bit of that play out because, Roberts has tried to put the brakes a little bit, but now that it's a 6-3 majority, he can't do it alone. And so with the Dobbs decision that you mentioned, for example, he would have done it a little differently. He ultimately sided with the decision, but he would have done it a little differently, slowed it down, gone through a different process. And so, you still have a supermajority that's conservative and it's going right. There's no question about that. The question then becomes with a lot of these cases is, okay, who might not go as far right as the Justice Thomas, Justice Alito, Justice Gorsuch would be the other one that's over there on the right. And so then you have this middle where it's Roberts, who's a little bit of a limiter, and then Kavanaugh has shown some flashes of being a limiter, and Amy Coney Barrett also has shown some flashes. And then you have the 3 liberal justices. So when you're looking at the court and how it's going in oral arguments, for example, you're really looking at those 3 in the middle that as to which way this might go.
And it is one of the interesting things about that too is that like when Antonin Scalia died in February of 2016, and Mitch McConnell, who was the Senate Majority Leader at the time, said, we're going to hold this open until after the election, even though Obama nominated Merrick Garland, and the merits of whether that of how kosher that was are still up to debate. Gorsuch got the nod there and became, like the person who replaced Scalia on the bench once Donald Trump was elected, and the Republicans, were able to retain their majority in the Senate. But ideologically, obviously each judge is different. They're not all. It's not just plug and play. You don't know exactly how they're going to run. But Gorsuch didn't change the ideological makeup of the court. He didn't change the dynamics as much as if Merrick Garland, had been confirmed. But then when Kennedy retired, even though Kennedy had also been appointed by Ronald Reagan, a Republican, Trump went with Kavanaugh, and you and I probably still bear the marks of the lash of that confirmation fight.
Quite a fight.
And it was, it was kind of a brutal one. It was highly contentious and emotional and so forth. Kavanaugh was confirmed ultimately. And, and then but he was still, if he's still in that middle block, call it maybe like the more establishment conservative block, if you will. Then Barrett, though, truly changed the character, as he said, with 6-3, replacing Ruth Bader Ginsburg. And that's when this came up. And I think that where I find this just so fascinating is that it hasn't all been just like 6-3. It hasn't even been 3-3-3 for that matter, because sometimes Gorsuch, who's a little bit more of a libertarian, will vote along with or like go off on his own and kind of current opinion, saying like, no, this is not like the way. Like I'm thinking of the the Oklahoma or the Native American jurisdiction case from a few years ago, where he's like, no, this is what the treaty says.
I think most people would point to, he ruled about discrimination in sex discrimination, and when there was an idea of what the text said and what it meant, and he sided with the liberals in that case, and got some criticism from the right. But it was also, I think you have to be very careful when you're talking about this, because it depends on the case, it depends on the issue, depends on if it's textual or constitutional, it depends on a lot of things as to where these justices will fall.
Right.
I mean, there's no way that you could avoid saying that some of them are consistently conservative or consistently side with the issues that Republicans would like the decision to go.
And then that just happens to align with mostly the politics of the presidents who nominate them.
Correct. and on the left, I mean, the left, the more liberal wing of the court has been I think less splintered than the right. They're more reliably side with the idea of what Democrats might want. But still, there's still a lot of unanimous decisions. There's still a lot of 7-2s or whatever. So you never really can generalize. But yeah, every time a justice lands on the court, it changes the dynamics of the court. And so exactly how that plays out is part of the fun of watching them as they're in these wrestling with these big issues that they're wrestling with.
Yeah. Let's talk about some of the cases that we are looking at, like most intently, in our capacity here at CQ and Roll Call. I mean, we've had this is some terms are defined by that one big case, whether it's presidential immunity or abortion, so forth. This has been I feel like the initial docket that we thought we would get when they announced didn't have that sort of blockbuster, that sort of Mission Impossible, sequel case. But it has only grown because of the number of appeals that particularly the administration is filing stemming from executive orders where people have challenged the legality of the executive orders, like birthright citizenship or something. And so we are done, as far as we know at this point, with oral arguments. They wrapped up last week, unless something unforeseen happens, like there's some sort of emergency case and they tell Souter he can't go jogging that morning because he's got to be in front of the court.
Caveat noted, yeah, but they don't have any other ones scheduled.
But let's talk about some of the big rulings that we're anticipating, because we're now in the stretch where we've got about 5-6 weeks. They don't always have to wrap up at the end of June, but they always do seem to. And then every once in a while they go into overtime, or they wrap up a little early. But what are the biggest ones that we're looking at, both from the cases that we knew about going into the term, as well as the ones that have come up with particularly related to actions by the administration that have been on appeal?
Just to explain a little bit the difference, there's these cases that have percolated slowly through the federal courts, and then they get up to the court, and then they schedule the arguments, and then the arguments go forward, and then they decide the case at the end of the term, at the conclusion of June or whatever. And then there's these other cases that are on an emergency basis, and those have sprung up from the Trump administration, which just started in January. Right. And they're not,
January of 10,000 years ago, right? It only seems like
yes, that, right? It feels that way. 3 months and 30 years ago. No, but essentially they're not fully, they're in a posture where they're not fully briefed. They're making these decisions about whether to allow something to go forward or not. They're not really deciding on the merits, and they've been bombarded with those as they have been in the past. It seems to be an increasingly busy part of their work. And so
a lot of them pertaining to deportations, immigration, and these opinions will come out in the middle of the night because time is kind of the essence. It's like, we have to rule now because they're putting people on planes and sending them to El Salvador,
right. Yes. So. I mean, and this is basically, those cases are all playing out with President Trump using his second term to try to remake the executive branch, press his authority, over Congress and over the courts. And so that is one, that emergency stuff is just sort of out there. Right. As far as the argued cases, we usually see, as you know, this rush at the end of the biggest, most contentious cases. We don't really know what's going on behind the scenes, but they're hashing out these decisions, sending opinions, drafts back and forth, and then they release them when they're ready. So a lot of the more contentious ones aren't ready till the last minute. Just like, as journalists, we have deadlines too. Right. So, but I mean, like going back, they still have cases going back to December that they haven't decided. They heard arguments, for example, over a Tennessee law that banned gender affirming care for minors. So dipping their toe into, the rights of transgender Americans and transgender children. Mm-hmm. The law blocks puberty. Bans puberty blockers, hormone therapy, surgery for minors. And it's being challenged as unconstitutionally discriminates on the basis of sex, which goes back to that like Gorsuch decision that I mentioned earlier. But it's in a constitutional context instead of a federal law context. So, even that kind of turn can decide. But essentially, it could lead to other states banning it if they allow it or not. So you have transgender rights up there. There's other cases that are, not as sexy, not as political, but that are really important. For instance, there's one about the National Environmental Policy Act and how much something like a railroad has to prepare an environmental impact statement for their project before it can go forward. Right. And it's the old regulation, over-regulation, under-regulation, environmental stuff. This is my favorite case of the term is they heard arguments about a Texas law that requires pornography websites to verify the age of their users. And, Texas is saying we're protecting children. The other side is saying, I think it's the ACLU challenging it, is saying this is a limitation on free speech. It's going to chill people from doing it. It's going to open them up to potential identity theft, fraud, other risks. And I mean, the way that the internet works these days, like just having to put your information to some maybe a potentially unscrupulous website.
Right. It's not just a matter of like when you go to a brewery's website to check their hours on Saturday to make sure that they're going to have the pizza truck there, and they say, "Are you 21?" and you click yes. That's not. It's not that.
I think the example that is in this case that is better is if you go into a pornography store and they say, "I need to see your ID to make sure you're 21," and they look at it, they're not keeping any of that information. It's not. Really. Or 18, or whatever it is. They're not keeping that information. They're not storing it. They're just looking at a license and then moving on. Right. Here, it's like it's in a database. It's stored. Who knows who's going to hack the database or whatever. So that one I think is pretty interesting. And I think some sites have already pulled out of Texas, and they're like, we're not even going to bother in Texas if we have to do this age verification thing. There's another guns case, which is the Mexican government is trying to sue U.S. gun manufacturers and hold them liable for cartel violence in Mexico for all the guns purchased from the United States that go down there. There's a case about the Louisiana congressional map. And this one is really crazy to me because it's about redistricting and it could potentially change how states use race in drawing these congressional lines. Louisiana drew a congressional map. It was challenged and a court found that it violated the Voting Rights Act. And then that map, after they redrew it, that map was challenged by a different group. And a different court said that violates the Constitution. So, Louisiana in this case went to the Supreme Court and was just like, what are we supposed to do? Because if we pay too much attention to race, it's a violation of the Constitution. If we don't pay enough, it doesn't give minority voters a chance to elect a representative of their choice in this district. So that could really, the redistricting lines rules have been really rolled back. And this could be another one where states get a freer hand to draw these lines. There's just briefly, there's one about South Carolina trying to deny federal funding for Planned Parenthood. And there's one about a mandate created by the 2010 healthcare law, Obamacare, that's to uphold a preventative care coverage mandate. And it's there's a group of businesses from Texas that don't like paying for HIV prevention drugs. And so then we have the birthright citizenship, which was the last one. It's a Trump's move to curtail who gets to be a citizen when they're born in the United States, depending on who they're born. And then there's this emergency docket stuff. And on the emergency docket, we have job protections for federal board members, and we have DOJ access to Social Security data. So that's still percolating as well. So I'm going to stop talking now because that's a lot.
Well, it is a lot, but I think it shows that, I mean, I think that rightly the court people noticed that the court was taking on fewer cases at a certain point, like sometime in the last 10, 20 years. And it was like, wait a second, what's going on here? Like their caseload is markedly changed. They're not taking on as many cases. And then we started to see an uptick of the use of what's called the shadow docket or the rocket docket or whatever you want to call it, like that, where you have these emergency appeals that go there, and that's that was previously kind of the purview of like the person on death row, right? Kind of thing. But now it goes back. Now it has started to accumulate where this docket is getting really busy because the administration continues to appeal because they keep losing in court. It's primarily their losses that they keep appealing, not not somebody who's suing, who's on the other side of it. It's increased the pressure on district and appellate judges because they're expected to process these cases, and they're also depending on how they rule, they're getting criticism from the president sometimes. I mean, judges have always, been criticized for going back to probably the dawn of time for their decisions. But when the president, who's theoretically a co-equal branch government, is criticizing, then that puts more pressure on the court itself, because it's like any number of the courts that were on the docket, the real docket, I hate to use the term real docket, but the one that we knew about in December, would be significant enough, whether it's redistricting or gun rights or transgender rights or, what have you. But then to also have to process all these things. And I don't know how many times you and your team have had to jump on something at 11 o'clock at night on a Friday because it's we have to do this because, again, people are literally being loaded onto planes.
Yeah.
And sent to a gulag, in El Salvador without any kind of due process. And that's been over and over again affirmed that judges are saying, no, we have to have due process. We're a nation of laws, whether it's a Trump appointee or somebody appointed by Carter or Reagan, it's been pretty consistent. These judges are we have to have due process for people. And then, every once in a while we get one of these rulings in the middle of the day, like yesterday, where we had two rulings. It's oh, wow.
Yes.
We get
So I think that came up. This has played out mostly what you're talking about in the birthright citizenship case, because the Trump administration appealed it, but they didn't appeal it on the merits. They just appealed it on this idea of that's a nationwide injunction that's stopping us from preparing to do this. And there were 3 nationwide injunctions. Every court that heard this said this is not how birthright citizenship is understood. The Trump administration has a new interpretation. It's been this other way for more than 100 years. It's not how the Constitution literally is written. So we're going to block you from implementing it. And when it got up to the Supreme Court,
Bill of Rights, technically, but right.
Oh yes,
or not Bill of Rights, amendments. It's Bill of Rights is only first 10, but
so
it's the 14th Amendment.
Yeah. So when it gets up to the court, Justice Kavanaugh asked a lot of interesting questions around this, because the idea is if they don't block it nationwide, then what happens to people that go from one state to another? New Jersey said, look, we have 6,000 children born to residents out of state every year. There's New Jersey residents are pregnant, they go out of state, have a child somewhere else. And so if it's challenged in one state and it's not challenged in another, how do you do that? And then it can take a year for the Supreme Court to decide the legality. So it could be a year where it's in effect, and ultimately, how do you unwind the harms? And he also said there have been nationwide injunctions that the Republicans liked. He mentioned the student loan thing from Biden. So it's really they're struggling with it too, because they don't want to be forced with having to decide stuff on the merits when it's on an emergency basis. And here Kavanaugh also said, I think it's a frustration because Congress hasn't been doing anything. Presidents are trying to implement solutions on their own to stuff like immigration. Mm-hmm. And so they're stretching or reinterpreting the laws, and that's pushing the boundaries. And so these lower judges are like, well, we have to decide against you because you're violating the law. And then the Trump administration says, well, it's happened 48 times or something in the first 2 months. Well, that's because they're really pushing the boundaries. Right. So, and then after they push the boundaries and the court stops, then Trump gets out there and all of the Trump administration gets out there and criticizes the judges.
Right. And I feel like this is, this is this is just my observation. There is no hard data on this, but we have seen a number of public statements by some of the justices, like John Roberts. He came up with when Trump had criticized the judge here in D.C. over, I can't remember what the ruling was. It was
Judge Boasberg,
yeah.
and it was that he found that the Alien Enemies Act, he ordered the Alien Enemies Act stopped. Trump had used a centuries-old wartime law that had only been used in wartime before. He decided that a Venezuelan criminal gang was doing an invasion.
Trump did, yes.
Trump did of the country, and then he wanted to use that to quickly deport alleged members of this gang.
Right. And Trump came out, criticized him, and that provoked a very rare public statement by the Chief Justice of the United States, John Roberts, saying, we don't, this is not how things work. Judges are not to, we don't impeach judges. I mean, we like he's Congress impeaches judges. But then since they've been on, the justices, particularly around graduation time, they tend to talk, like Roberts was speaking to Georgetown Law a couple of weeks ago. In sort of a symposium, he didn't have the funny hat on and all that kind of stuff. He actually just had a suit on, which was kind of jarring. It's weird. Like, I can't remember the last time I saw John Roberts was just a suit on. It was at when George W. Bush introduced him at the White House. I've always seen him in robes. And then Ketanji Brown Jackson was in a conference in, I think it was in Puerto Rico, and she was talking about, threats to judges and how much more difficult it is to do things in this environment. And I feel like, what's your feeling about that? Again, we're not working off hard data, but there seems to be more willingness for the justices to talk about these issues, which are in the public and their political fights than previously, it seems.
Well, yeah. I think that a lot of the justices, they don't want to necessarily make these comments, but then they get kind of forced into it because they are creatures of Washington, and they're an entire branch of government. And when they're getting bombarded, I think that there is this feeling that they need to push back, especially when they feel like this is how it's always been done. And we're just doing our job. Like Chief Justice Roberts, when saying that, impeachment is not an appropriate response to disagreement with a judicial decision. He said the normal appellate review process exists for that purpose. Like, this is how we handle it. You just have to be patient. We're putting the rule of law up there. And Ketanji Brown Jackson, when she was in Puerto Rico at this conference, she said that judges are facing increased threats of physical violence, but also professional retaliation just for doing our jobs, she said. And she also said that they seem designed to intimidate those justices and judges. And the judicial conference, when they put their budget request in, we watched that very closely here. They put their budget request in. They asked for more money for protection for judges, inciting increased number of threats. So I do think that and that's happened for members of Congress too, increased threats. So I do think that there is a lot of churn out there right now. And with Trump and people jumping on it and wanting Trump and Republicans wanting to get this stuff done, getting frustrated by the courts. But on the flip side, you had Kagan, and I'm getting this from Bloomberg Law, reported on it, but she said that the public is entitled to express their views on whether the court's doing its job properly, right? So it's like it shouldn't be off limits,
right,
to criticize the justices if they do something wrong. I think that, going to threats obviously is a new territory. And there was, I believe there was even a Trump truth over the weekend that sort of he retweeted somebody else that kind of insinuated that maybe we should put some of these violent criminals near Supreme Court justice houses, and so it's just kind of that's sort of crossing a line. But the court its biggest weapon is that it has to explain everything that it does, and it has to justify everything based on the law, based on the facts. Yeah. A lot of people criticize them for coming to a Republican or Democratic side kind of point of view based on the president that appointed them. But, they have to explain everything, and they have to do it in writing.
Right.
And so we should demand that they do that. And so that's how the courts operate, and people should be feel free to criticize them.
Yeah.
So,
last thing I want to mention about the court before we get to words of the week, which I'm very excited about this for reasons that will become obvious soon, is earlier this month, David Souter, former justice on the Supreme Court, nominated by George H.W. Bush. He died at the age of 85. He had been retired for, I think,
19 years.
Yeah, 19 years. He had gone back to New Hampshire or Massachusetts. He never made his dislike of being in Washington subtle. And he kind of kept to himself. He had a small apartment here, but it was like he couldn't wait to get back home to New England. And, he's just got kind of this quirky character. He had I think one of his houses had to be like abandoned because he had too many books or something like that, which I totally relate to, being a book person with a book problem. But he also changed the way that I think the confirmation process worked, which is something that you and your team noted. Mike McAnony did that obit for us. And part of it was that his views weren't as obvious during the confirmation process. And then even though he was nominated by a Republican, he tended to drift more towards the Democratic or liberal or even libertarian viewpoint on a court that was increasingly going right through the 90s
Yes.
and the 2000s, even leading to a chant of "No more suitors." Was a chant that we needed to, from the Republican perspective, we needed to definitely get it so far into the background that there was never going to be a question about where somebody would rule on abortion or gay rights or how money is appropriated by Congress and spent by the executive, things like that. And of course, that's adorable to think that you can always figure out exactly how somebody's going to rule, as we found out just with the last few justices. They are human beings. They all bring their own unique perspective. But Souter did sort of change a lot of those dynamics. And I don't know.
Yes.
I know that there was a little before your time as a full-time Supreme Court reporter that he was here, but just an interesting cat for sure.
Yeah, yes. He was the kind of the fun thing that our reporter Michael McAnony dug up when we were looking at this is that he was the last appointee by a Republican president to receive 90 votes for confirmation out of 100.
Yeah.
And since his retirement, no nominee from either party has received more than 60 confirmation votes. And he's just been a boogeyman for a while. And the conservative legal movement, which really started with Roe v. Wade, which established the constitutional right for an abortion, they started there and they were working to overturn that. They got it done. But that movement, they were the ones that said, we learned our lesson. We need more of a proven track record of conservative decisions or writings. And because you get more of a track record, then you get more opposition from the other side. And you eliminate as much of the somebody getting wishy-washy or moving towards the middle or something when they get to the bench, the more independent they could be. And, to your point about his, I guess his reputation, Canon Shanmugam, who's a Supreme Court appellate lawyer, really nice guy. He argues before them all the time. He did a nice tweet that I thought was pretty great. He said, he was a peach of a man, and he said that, he noted the "no more suitors" line. And then he said, but I wonder whether in this fractious time, we actually need more David Souters rather than fewer. And that the world felt poorer without David Souter in it. So, I mean, it does harken back to this era of before all these contentious, and then even now, there were some, in the very online sphere, there's Republicans and conservatives who are starting to think that Justice Amy Coney Barrett is going a little, too liberal. And, even just the way that she looked at Trump at the, State of the State or whatever, State of the Union, but it wasn't that. It was joint address to Congress. Yes. The way she looked at him during that, it was like, oh, look, she doesn't like him. And Chief Justice Roberts has sort of been on the outs with the Federalist Society since he voted to uphold the 2010 healthcare law, Obamacare. So there's sort of a purity that is demanded on the right, and we haven't seen that as much on the left, but that's because they just haven't had a chance to appoint anybody.
I mean, purity tests come into view when the dominant party is in power, and or when a party has a dominant position, and people are just sort of jockeying for that. And I think that we have seen that particularly in this Congress, and this is a podcast more about the court, but this Congress among the Republicans, there are daily purity tests for the affections of Donald Trump, to show how loyal that they are to his agenda, and it's. That is frequently the case when you have like a trifecta government. We don't have them that often, once every 4 or 8 years. But purity tests, are a great way to sink your majority. As the Republicans found out in 2018, as the Democrats found out in 2022. I mean, you could make a good argument that the internal strife in the parties is really what did them in terms of any kind of accomplishments they were looking for.
Well, and on that vein, there are at least 4 impeachment resolutions against 4 different judges. Right. Yeah. This Congress in the House.
Good stuff. I would be remiss, just a caveat too, Souter also liked to run, so he's going to get a good audience with us. And then the books thing. He had these there were these stories about him basically had an apple and yogurt for lunch every day or something like that. And one time I remember this anecdote about him, that the power went out in the court, and his clerks actually didn't have any problem adjusting to it because he never read by electric light as much if he could help it. He was just reading by natural light in his quarters and or his office space in the court. So I don't know. I tend to think that just from a temperament perspective, it would be good to have a few more David Souters. I'm all for embracing the weird. So speaking of weird, we're getting weird with words of the week this week. I wanted to have something legal. You dug up something that just kind of rules. So I'm going to let you take the word of the week for its explanation, because this is a good one.
All right. So I don't know what the preamble.
There is no. This
no
is
preamble. All right. Well, the word of the week then is ultra vires.
So awesome.
Ultra vires. Well, it's 2 words really.
Yes,
but it's Latin. Per Cornell Law School's Law Encyclopedia, the Latin phrase means beyond the powers.
Right.
And it means an action that exceeds the legal scope of authority.
Right.
And the reason that that's the word this week is it was used frequently in a decision by a judge here in the District of Columbia. She was reviewing the actions of the Trump administration when they did a dramatic takeover of the U.S. Institute of Peace in March. It involved a contractor breaking into the building, ousted president, ousted board members, newly installed board members. And the judge sided with the ousted board members in this lawsuit, and said that all those moves were contrary to the way that Congress set up this institute that was supposed to just try to find out more about peace, and that they did it so that a president couldn't do what Trump just tried to do. And I'll just read her quote. Yeah. Congress's restrictions on the president's removal power of USIP board members are squarely constitutional, and the president and his administration's acts to the contrary are unlawful and ultra vires.
Ultra vires. This may be a little difficult for me to admit because I've picked all the previous words of the week, but I think that tops it for words of the week. That I can't beat any of those. So well done, bravo, sir.
And if the Latin pronunciation is a little off, so be it. I don't speak Latin, and a lot of Latin words in the law are said many different ways by many different people. So all suggestions accepted.
All right. I have to admit too that even though the 1 year I went to parochial school, Jesuit school at Brophy College Prep in Phoenix, I did not take Latin. I took Spanish. So I'll ask my stepson. He took years of Latin.
There you go.
Here in DC at Latin. Anyway, Todd, thank you so much for talking about the Supreme Court. That was a lot of Supreme Court. I'm very happy about it.
It was. Thanks for having me. Always fun.
Yeah. And thank you out there for listening to Political Theater Podcast. Tell your friends about us. Subscribe to our newsletter, rate us on Apple Podcasts, and we'll see you next week.